Recording. And I would like to welcome you all to Let's Talk ICT. In this session, we're going to have a presenter talk about captioning and visual accessibility. And this is addressing how to provide visual accessibility for deaf and hard of hearing individuals using methods such as open and closed captions, sign language, and transcripts. And we're excited today to have with us our presenter, Dave Kingsbury. He's the director of the Deaf Services for the Missouri Department of Mental Health. He also serves as their department's web accessibility coordinator. So he is full of a lot of information that's helpful for us as we all move into this area of digital accessibility. So thank you very much for all of you joining us, and I will turn it over to Dave.
Good afternoon. It's great to be here. I appreciate all of you participating in the training this afternoon. So I am the Director of Deaf Services for the Missouri Department of Mental Health. Just quickly, if you're interested in learning more about the Office of Deaf Services and how all the Department of Mental Health supports and serves deaf people in Missouri, I'd encourage you to check out dmh.mo.gov/deaf services. All right, so in today's workshop, we're going to spend roughly the first half talking about legal and technical standards for visual accessibility. There are quite a few sources for the requirements, so I'm going to outline those sources for you. It's really going to be a high-level summary of the sources and what applies to whom. I'm going to get more into the nuts and bolts of the actual standards and how to achieve compliance with the standards. And then we're going to talk a little bit more specifically about captioning, ASL interpreting, and transcripts, and types of issues that come up when providing those types of accessibility options. And then to close things out, I'm going to share resources to help you implement these types of accessibility solutions. So briefly, a note on preferred terms. When you're reading in print, you might see the term deaf with a little d or deaf with a uppercase D. Sometimes you might even see capital D/lowercase d deaf. Deaf with a lowercase d is usually referring to the medical condition of a hearing loss that's severe to profound, or it can refer to functional deafness. It can also refer to deafness just in a generic sense, whereas deaf with a capital D is typically used to denote a cultural identity, a person who will typically use American Sign Language or ASL as their primary language and identify with the culturally deaf community within the United States, or possibly the deaf community in some other country. The term hard of hearing typically refers to people who have a hearing loss that is significant, but still allows them to effectively communicate through speech and listening, and typically would not be culturally deaf, although some people who are hard of hearing do consider themselves culturally deaf and may use American Sign Language as well. So there's some diversity there. Best practice when we're talking about deaf and hard of hearing people, or the deaf and hard of hearing community, is to avoid using person-first language unless the person specifically requests it. So a lot of times you might hear a recommendation to use person-first language, where we might say a person who is deaf or a person who is hard of hearing. And by and large, the deaf community prefers what's called identity-first language. A lot of deaf people view their identity or their deafness, their experience, their use of American Sign Language as assets or advantages, and they don't necessarily see themselves as having a deficit or a disability. And so for those reasons, a lot of people prefer identity first language instead of person first language. But again, there are individual differences. If a person requests person first language, then certainly we want to honor that. And similarly, best practice is to avoid using the term hearing impaired, which is generally viewed as focusing on the deficit or the disability rather than the unique experience and strengths that deaf people have and the language that they value. Again, unless a person self-identifies with the term hearing impaired. All right, so the heart of today's workshop, visual accessibility, the legal and technical standards that help us understand when we have to provide visual accessibility and how we have to provide visual accessibility. We're going to be talking about the disability assistance chapter 161 in Missouri statutes, the state ICT standard, the Rehabilitation Act, Section 504, the first three titles of the Americans with Disabilities Act, just a little bit on the Affordable Care Act, Section 1557, and then, of course, the Web Content Accessibility Guidelines. So Missouri statute at chapter 161.935 requires all state departments and agencies to ensure that our uses of information and communication technologies are accessible to individuals with disabilities. Now, this statute does not define what it means to make information communication technologies or ICT accessible. Rather, it assigns that responsibility to ITSD, the State Information Technology Services Division, and the Missouri Assistive Technology Council to work together to adopt accessibility standards that tell those of us who work for state agencies what we need to do to make our ICT uses accessible. So the state ICT standard requires that state agencies ensure that uses of ICT are accessible to individuals with disability, and more specifically, it requires compliance with the Web Content Accessibility Guidelines, or WCAG for short. It refers to the 2.0 version of the standards, and then within those standards, we have three levels of compliance. We have level A, level AA, and level AAA. Specifically, the state ICT standards say that we need to follow levels A and AA. Level AAA compliance is optional, and I would consider it to be best practice. Sometimes AAA standards can be achieved with just a little bit of extra effort, but sometimes the AAA standards can require significant additional time and resources to implement. So it's not always practical to try to achieve those AAA standards. The Rehabilitation Act, Section 504, is a federal law that applies to all recipients of federal financial assistance. It prohibits discrimination on the basis of disability. I'm not really going to talk further about Section 504 because in almost all cases, if you're in compliance with the Americans with Disabilities Act requirements, you're also going to be in compliance with Section 504 requirements. But if you have specific questions about that, then I'd encourage you to talk to me, contact me after the presentation, and I can get into all of the details with you if that would be helpful to you. So Americans with Disabilities Act, or ADA, Title I of the ADA applies to employers with 15 or more employees. This is true whether the employer is a private entity, a nonprofit, or a government entity. Title I requires reasonable accommodations for qualified individuals with disabilities, and these individuals who are qualified are applicants and employees who meet the qualifications for positions, employment positions with a particular organization or agency. And what is a reasonable accommodation that's appropriate to provide is determined on an individual basis based on an interactive process with the person with a disability. Title II of the Americans with Disabilities Act applies to public entities, which is basically state and local government entities. So Section 504 actually applies to the federal government, but Title II of the ADA does not. It just applies to state and local government. One thing that's often overlooked in ADA Title II is that it doesn't only apply directly to the state and local government, but it also applies to any instrumentality of government, and it applies to any programs, services, or activities that even if they're not provided directly by that public entity, they might be made available through contractual, licensure, or other arrangements. And so, for example, if the Department of Natural Resources contracts with vendors or concessionaires to operate a marina or lodging or food services or things like that within a state park, or if the Department of Mental Health contracts with a private mental health center to provide mental health services, all of those are activities of state and local government provided through contractual or other arrangements, and those services have to meet ADA standard, Title II standards as well. So, for example, if a marina is operated under contract with the Department of Natural Resources, that marina has a website. That website needs to be accessible to people with disabilities, and the DNR is responsible to ensure that that website by their contracted vendor meets appropriate accessibility standards. So there are three broad accessibility standards within ADA Title II: equal access and equal opportunity to participate and benefit from the programs, services, or the other things being provided. And then so the first two are equal access and equal opportunity. The third is equally effective communication with people with disabilities. And this is a separate requirement from the other two. So even if a person in theory could access and participate in the programs or services on an equal basis, but not have equally effective communication, there's still this third independent requirement to provide equally effective communication. In reality, if we're not providing equally effective communication, then the person probably isn't really receiving an equal opportunity to participate or benefit. So equally effective communication means communication with a person with a disability that is as effective as communication with people without disabilities. Now, as part of this equally effective communication requirement, Title II of the ADA requires the provision of auxiliary aids and services when necessary for effective communication. This also includes what's called a primary consideration requirement. It's a requirement that primary consideration be given to the auxiliary aid or service requested by the person with a disability, and these requests must be honored with limited exceptions. So the idea is that the person with the disability is really the expert on what type of communication is going to be most effective for them, and And so we need to provide them with an opportunity to make that request, and we generally have to honor that request unless we can prove that some alternative we'd offer is as effective as what they requested. Title III of the Americans with Disabilities Act applies to public accommodations, which, as opposed to public entities being government entities, public accommodations means businesses and nonprofits that serve the general public. Title III also requires equal access, equal opportunity, and equally effective communication. However, in the provision of auxiliary aids and services, there is a lower standard. The auxiliary aids and services under Title III still must be effective, but Title III does not include the primary consideration requirement like Title II does. And so under Title III, that business or nonprofit can decide what type of auxiliary aid or service to provide, as long as it is actually effective in meeting the communication needs of the particular individual in question, considering the nature of the communication and the circumstances in the particular case. So it's not something that allows a one-size-fits-all or one-size-fits-most solution. It still requires an individualized assessment, but it doesn't have that same more stringent primary consideration requirement that applies to government. Now, under both Titles II and III, examples of auxiliary aids and services for visual accessibility for people who are deaf and hard of hearing might include qualified interpreters, open and closed captioning, including real-time captioning, accessible electronic and information technology, or any other effective method of making auditory information accessible to people who are deaf and hard of hearing. Title I for employment doesn't use the term auxiliary aids and services, but these would also be example of reasonable accommodations under ADA Title I. Now, when we're talking about interpreting services, historically, interpreting services have been provided on site, but with the advance of video and internet technologies, there is now a service called Video Remote Interpreting Service that's specifically recognized by the ADA. Now, it's not appropriate for all situations. And so if VRI is going to be used, it still has to be appropriate and effective for the particular circumstances. Part of that consideration is there are technical standards within the ADA for the provision of video remote interpreting services. This includes real-time full motion video and audio that has to be over a dedicated high-speed wide bandwidth video connection or wireless connection that delivers high-quality video images that do not produce lags, choppy, blurry, or grainy images, or irregular pauses in communication. And so basically, the quality of the video itself and the connection that's delivering the video has to be high quality so that it doesn't interfere with the effectiveness of the communication. The standards also require a sharply delineated image that is large enough to display the interpreter's face, arms, hands, and fingers, and the participating individual's face, arms, hands, and fingers, regardless of their body position. So this is addressing the quality or the resolution and the size of the screen, and also the quality or resolution and the field of view of the camera has to be sufficient to allow effective communication as well. And then third, a clear audible transmission of voices. And so that audio component is an important part of allowing effective communication for VRI services as well. Now, ADA Titles 2 and 3 have certain prohibitions, including they prohibit requiring or requesting that a person provide their own auxiliary aids and services. So you can't ask a person to provide their own interpreter. The ADA also prohibits charging a person for providing them with an auxiliary aid or service. So we can't say, all right, I'm going to provide you with an interpreter, but you need to reimburse us for the cost for that. That's prohibited as well. Auxiliary aids and services have to be provided at no cost to the individuals who need them. Now, when it comes to the Americans with Disabilities Act and technical standards for web accessibility or for ICT, information and communication technologies, the U.S. Department of Justice at one point had started to develop specific standards and rules, but they never finished those. They never published those. And so at this point, there are not specific technical standards required by the ADA for these types of uses. But it is the position of the Department of Justice that the ADA does apply to websites and other uses of information and communication technologies. They still need to be accessible. The ADA just doesn't have rules specifying technically how to achieve that. But several lawsuits have enforced application of the ADA to websites and things like that. One example of that would be the lawsuit that the National Association of the Deaf brought against Harvard University and the Massachusetts Institute of Technology because they had educational videos on their websites that were not captioned and not accessible to people who were deaf and hard of hearing. That lawsuit was a major win for the National Association of the Deaf. And a lot of these lawsuits in the settlement agreements or the consent decrees will reference the WCAG standards. And so from a preventive law standpoint, I think it's advisable to kind of assume that the ADA applies the WCAG standards, or if there's some equivalent alternative that achieves the same outcome but isn't actually the WCAG standard, then that would probably be okay too. But we need to be thinking about that end result and those overall standards of equal access, equal opportunity, and equally effective communication. Now, there's also a newer non-discrimination law, the Affordable Care Act, Section 1557. This applies to health programs or activities, any part of which receives federal financial assistance from the U.S. Department of Health and Human Services. So examples of Missouri state agencies this would apply to include the Department of Health and Senior Services, the Department of Mental Health, and the Department of Social Services. By and large, hospitals are also required to comply with ACA Section 1557. Health clinics, healthcare providers that accept Medicare or Medicaid payments, they're recipients of federal financial assistance through the Department of Health and Human Services, so this would apply to them as well. Section 1557 requires that these health programs and activities, if they're provided through information and communication technologies, they have to be accessible to individuals with disabilities. There are other requirements as well in Section 1557 that I'm not able to cover today. But there is specifically an ICT accessibility requirement here that I wanted to mention. Now, moving on to the WCAG technical standards, I want to point out a distinction here where state statutes and the state ITC or ICT standards require that state agencies conform to levels A and AA. So this is a legal requirement for Missouri state departments and agencies. Conformance is not expressly required by the ADA, but like I mentioned, they've often been referenced in court orders and settlement agreements. So the first WCAG standard we're going to look at is 1.2.1, which is a level A standard that applies to audio only pre-recorded content. So a common example of this type of content would be a podcast. The standard requires that alternate information be provided that presents equivalent information. An example of a sufficient technique for this standard would be to provide a transcript that provides, one, a verbatim account of everything that is said, verbatim and everything being keywords here. Two, it has to identify who is speaking. So if there's just a single speaker the entire time, that can just be identified once at the beginning. But if you have a dialogue between two people or multiple people, each time the speaker changes, that transcript needs to identify the change in speaker and who is now speaking. It also needs to describe any meaningful non-speech sounds that are part of that audio only content. And so if there's theme music at the beginning, that's probably not meaningful content in most cases. And so that, the transcript might put in parentheses that there's music, but that wouldn't be required. But, if there are like bell sounds or buzzer sounds or applause or things that contribute meaning to the content, then those meaningful non-speech sounds need to be described in the transcript in order for it to meet standards. All right, standard 1.2.2 is a level A standard. It applies to captions for pre-recorded audio in synchronized media. And so a common example of this would be a video that includes audio content. So again, we're required to provide an alternative that presents equivalent information. Sufficient technique in this case would be open or closed captions, and we'll talk about what those terms mean a little bit later, but open or closed captions that provide a verbatim account of everything that is said. Again, the keywords being verbatim and everything. Again, it has to identify the speaker. It again has to describe meaningful non-speech sounds. And then an additional requirement here, because the person is following along with the video typically, is that these captions have to be synchronized to the audio content in the video. Standard 1.2.4 is a level AA standard, and it applies to captions for live audio in synchronized media. So here we might be talking about a live stream or a webinar or a virtual meeting or something like that. Those would be examples of synchronized media that include live audio. So again, there's the requirement for an alternative that presents equivalent information, and a sufficient technique would be open or closed captions that provide an accurate account of everything that is said. Notice here, the word is accurate instead of verbatim. So that's a little bit less stringent, which is a consideration for the fact that this is live versus something that's pre-recorded and pre-produced. Again, they have to identify who's speaking, describe meaningful non-speech sounds, and here, instead of being synchronized, they have to be provided in real time. And that difference in terminology, real time instead of synchronized, recognizes that when captions are provided for a live event, it's necessary for there to be some amount of lag time for processing in order for those captions to be produced. And so it's acceptable and in fact necessary for there to be some lag time between the actual speech and the display of captions, whereas in a pre-recorded video, there needs to be full synchronization so that the captions completely match up with the presentation of that audio. All right, standard 1.2.6. Now, this is a level AAA standard, and if you recall, we said that AAA standards for state agencies are optional, whereas the level A and AA standards we've been discussing are required by state statute and ICT standards. So here, the standard is that sign language interpretation be provided for pre-recorded audio in synchronized media. So again, we're talking about pre-recorded video with audio content. And again, a requirement that an alternative provide equivalent information. And the sufficient technique here is a sign language interpreter is provided. Now here, in the previous standards, when we discussed the sufficient techniques, to be sufficient, the technique had to meet all of the criteria I explained. Here, this is providing options, and so the sign language interpreter may be displayed in any one of these three ways to meet the standard, to be a sufficient technique. One, included in the video stream itself. Two, displayed in a different viewport. For example, a deaf person who requests an interpreter could be provided with a URL that allows them to open a full screen display of an interpreter on their iPad while viewing the regular screen view of the videos on their computer screen or something like that. There's also an option for the interpreter to be overlaid on the video stream image by the player. And so this might be something like picture in picture, whereas where it says included in the video stream, that might be a single camera that shows a presenter and then the interpreter is in the same video frame standing next to the presenter, something like that. So there's some flexibility in how this can be achieved. Now, the scope of application of these standards, the state ICT standard says that these WCAG standards apply to all impacted state information systems, tools, and information content. So this is very broad. This would include content like electronic documents, images, sound, multimedia, and so on. So the actual electronic information content itself, and also tools or delivery platforms that are used. So these might be internal and external websites, web portals, software, virtual meetings, electronic surveys, live streams, YouTube channels, telehealth platforms, and so on. There are many examples that would all be considered ICT and need to meet these WCAG standards for state agencies. Now, the scope of application of Title II of the Americans with Disabilities Act. Title II applies to everything the public entity does. There are really no exceptions to it. Title III of the ADA for businesses and nonprofits that are private entities providing goods or services to the public. Here, the scope of application is a little more limited. It applies to all operations of a place of public accommodation, whether physical or electronic. Now, I also want to point out some differences in the nature of the application between the WCAG standards and what the ADA and ACA Section 1557 require. So the WCAG standards define baseline requirements that need to be in place in advance. And the reason for this is that it ensures the content is accessible to most users with disabilities without that user having to reach out and request an individualized accommodation or auxiliary aid or service. Whereas what the ADA and ACA Section 1557 define are general accessibility standards, but they also require individual accommodations upon request or when an entity becomes aware that an accommodation is needed. And so when we meet the WCAG standards in advance, that means most of the information is going to be accessible to most people with disabilities, and that greatly reduces the need to divert staff and resources to address individual employee or constituent or customer requests for information or content to be made accessible. But there will be cases where even if we comply with WCAG standards, that content isn't going to be accessible to everybody regardless of their type of disability. And so under the ADA and ACA, we still do need to accommodate those individualized requests. And so an example of that, with that AAA standard for interpreting for pre-recorded video, the WCAG standards don't require that in advance, but we still might have an individual who needs that in order to fully access, to fully understand content. And so that interpretation might need to be created and provided upon an individual request under the ADA, even though it's not required by WCAG or the state ICT standards. Now, there are some defenses to these requirements that I'm just really going to briefly touch on. The main one, it's called an undue burden defense, which means significant difficulty or expense. But for a state or government entity, in determining what's an undue burden, the financial and personnel resources of the entire state are considered, not just a particular department or office or unit. Under ADA Title II and ACA Section 1557, the decision that something is an undue burden has to be made by a department head or their designee. It's an affirmative defense, which means the burden of proof is on the organization or entity to show that that an undue burden actually exists. But this is very difficult to prove, given the resources available to government entities. Undue financial burden defenses in particular are almost never successful. And even if undue burden can be shown, we are still required to do the next most effective thing that would not result in an undue burden. And so it's not that it completely relieves an organization of the requirement to provide effective communication. It just would mean, okay, they're not required to provide this particular thing that's an undue burden, but they still need to figure out what is not an undue burden that will be as effective as possible. All right, moving on to look specifically at captioning. We're going to draw the distinction between different types of captions. Captions can be provided live or in real time, which means they're produced concurrently with a live stream or a live event. Pre-produced captions would be produced for pre-recorded video, and so they're prepared in advance of when the user is viewing those captions and the content. We also have open captions versus closed captions. Now, open captions are burned into the original video file, which means they are permanently visible to all viewers. The advantage of this is that it maintains accessibility regardless of what is later done with that file, if it's shared by email or a file sharing resource or things like that. Because those captions are burned in, those captions can't get separated or left behind from that file, and that accessibility will still be there. But open captions, because they're burned in, they're the digital text readability of that content is not preserved, which means it cannot be indexed by search engines. Closed captions, on the other hand, are contained in a separate sidecar file. This allows individual users to turn the display of the captions on or off to match their individual preferences. A lot of people find captions very helpful, even if they're not deaf or hard of hearing, but some people find them distracting, especially if the synchronization isn't right. They can be distracting. And so this does allow that flexibility. When we use closed captioning, that sidecar file is going to be in a specific format. There are several different types of formats. And while most players will support a range of formats, not all players support all formats. So you do need to ensure compatibility between your captioning file format and the player that is being used. Another advantage of closed captioning is because it's actually a text file that can be indexed by search engines, which makes the content of your video searchable and can improve search result rankings for your websites with video content. So that can be a pretty significant advantage. We also have automated captioning, which is also sometimes referred to as auto captions or automatic speech recognition, ASR for short. Automated captioning is produced by computer software or artificial intelligence without any human editing or processing involved. But then we also have human captioning, which is produced by humans, and this might be done with or without the aid of software or AI. So even if software or AI is used to make the process more efficient or faster, there's still a human involved to review and make corrections to increase the accuracy of the final captioning product. Which leads into talking about the accuracy of captions. Now, when we're talking about captioning accuracy, it's important to understand there are several different types of accuracy. First is word accuracy, which is a percentage of the words correct, the words that are incorrect, substitutions, which means it's not just a misspelling or a gibberish word, but there's an actual word there that is not the word that was actually spoken. There are also insertions, which are words in the captioning that the speaker did not say, and then deletions, words that are missing. And so you could have the words that are displayed be all correct, but have some words missing. And you could have all of the words that were said correctly displayed, but have extra words that shouldn't be there. So there are these different types of word accuracy errors that all need to be accounted for. But in addition to word accuracy, we also need to consider formatting accuracy, which includes punctuation, capitalization, grammar, speaker identification, and non-speech elements, which we've talked about are part of these WCAG standards. So overall accuracy involves both word accuracy and formatting accuracy. But when you see AI captioning accuracy advertised, typically that's just referring to word accuracy, and that's also typically done. That's typically measured in testing that's based on ideal speech samples, where there's no accents, there's no background noises, the person is articulating clearly at a comfortable pace, things like that. So not real world conditions where accuracy can really suffer. We can get an estimate of overall accuracy by multiplying word accuracy times formatting accuracy. Last year, 3Play Media did research using real world samples of audio content from a range of industries, education, government, entertainment, these different settings. And they assessed both the word accuracy and formatting accuracy of a number of different popular auto caption engines. And here I'm presenting the results just of the top 4. Now, you've probably heard of Microsoft, Google Video. The most accurate was 3Play's engine, which is actually the Speechmatics engine plus additional post-processing. And you can see by the time we account for all of these different types of potential errors, the overall accuracy of even the best option out there was only about 76%. Now, if you keep in mind the standard of equally effective communication, 76% effective is not equally effective. Or if you keep in mind, we talked about the standards in WCAG, verbatim, and everything that's said, all of these different elements, and 76% accuracy just does not meet these standards. According to the World Wide Web Consortia, or W3C, which is the organization that develops the WCAG standards, automatically generated captions do not meet user needs or accessibility requirements unless they are confirmed to be fully accurate. Usually they need significant editing. There are tools that use speech recognition technology to turn a soundtrack into a timed caption file. For example, some common video websites provide automatic captions. However, often the automatic caption text is wrong and does not match the spoken audio, sometimes in ways that change the meaning or are embarrassing. For example, missing just one word, such as not, can make the captions contradict the actual audio content. So while there isn't a quantitative accuracy standard in either WCAG or the ADA, it's when you look at the case law and the settlement agreements, it's generally viewed as 99% accuracy is the expectation for pre-recorded content, and somewhat lesser accuracy would be expected in live or real-time settings, just because there isn't that same opportunity for verification before that final product is output. So I'd say, neighborhood of 95% is a realistic standard for live settings. But these accuracy standards are very important, and this highlights why auto captioning typically does not meet accessibility standards. Now, there are a variety of captioning use cases. We've talked about live versus pre-recorded and the implications of that. we're not going to be able to achieve quite the same accuracy or the same degree of synchronization in a live setting, but we should expect that from pre-recorded. Now, I want to mention there's a difference between internal captioning uses or situations where advanced registration is required versus something that's open access. If we have a work group with regular internal meetings, that work group generally is going to know if one of their members needs captioning or other accessibility, and so that can be taken into consideration. In events where advanced registration is required, there's an opportunity for a person with a disability to request their particular accommodation in advance. And so you can know whether or not a particular accommodation is needed. But if something is open access, if a live stream is just broadcast for anybody to access, no pre-registration required, or if something is posted on a state agency's YouTube channel, that's open to everybody. And it's really important that the required captioning be provided to the appropriate accuracy standards. And then I also mentioned live with the recording posted afterward. You might provide that live captioning for the live event that is not quite as accurate as pre-produced captioning. But once you take that video recording of the live event and you post it, now that it's posted and it's accessible on an ongoing basis, that is now pre-recorded, pre-reduced, and it has to meet the accessibility standards for pre-recorded, pre-reduced content, not just the lower accessibility standards for live content. All right, ASL interpreting. When interpreters are used, we already talked about the VRI or video remote interpreting technical standards, but there are also quality standards for the use of interpreters. Interpreters must be qualified. That means they have to adhere to ethics and confidentiality standards. They have to be proficient in both of the languages that are involved in the interpreting. And they have to be able to interpret effectively, accurately, and impartially using any necessary specialized words or phrases. So even if they're generally proficient in English and American Sign Language, they might be an outstanding interpreter in a medical setting or a mental health setting and have specialized training and experience. But then if you put them in a felony legal setting, they might not know the specialized vocabulary necessary for that legal setting. So this is context specific in terms of number 3. So they have to be qualified. In Missouri, Missouri statutes require that interpreters be licensed by the Division of Professional Registration and be certified at the skill level required for the assignment in a statute that's promulgated by the Missouri Commission for the Deaf and Hard of Hearing. So they can be certified at the basic, advanced, or master level, and that CSR defines different types of settings and whether they need to be certified at least the basic, advanced, or master level for a particular setting. Now, it's important to realize that these requirements for qualification, Missouri licensure, and Missouri certification apply to VRI interpreters and on-site interpreters. So if the interpreting is being done for people in Missouri, but the VRI interpreter is in Texas, that VRI interpreter in Texas still needs to have Missouri licensure and certification in order to interpret over VRI for people in Missouri. So examples of use cases here would be a virtual meeting or webinar where the interpreter might be integrated into that virtual meeting or webinar, or the person who needs the interpretation could receive a web link to display it on a separate screen or something like that. The same thing is true of a live stream. And then for pre-recorded videos, that interpreter can be part of the original video, or you can have one version of the video without an interpreter, and you can have an alternate version of the video with an interpreter. So again, there's flexibility in how this is provided in different cases. Then transcripts. My experience has been when I request a transcript, I get back a raw transcript that's usually pretty accurate. I might need to fix a word or two or a little bit of punctuation. I'll usually want to check the paragraph breaks to make sure they're where I want them. I'll usually need to add identification of speakers myself. And then how to do this is beyond the scope of today's webinar, but you also want to make sure that that final transcript document meets WCAG standards for electronic document accessibility. So use cases here, we already mentioned podcasts. Any other type of pre-recorded audio would fall under this as well. And there can also be transcripts for pre-recorded video. That's actually a different WCAG standard that we didn't have time to discuss, because that also includes taking descriptive audio content and putting that into the transcript. But that expanded use of transcript can be used for pre-recorded videos as well. And that can make the videos accessible to people who are both deaf and blind. All right. Some resources to implement these accessibility techniques for live or real-time captioning. A great resource is Relay Missouri's Relay Conference Captioning Service. It's funded by the FCC, which means it's free to end users for eligible virtual meetings and events. You can learn more about that or request that service at relaymissouri.com/RCC. CCC Services is a provider of on-site and remote real-time captioning. They're the captioning provider for today's workshop. You can learn more about their services at cccaptioning.com. At DMH, we've used Quality Transcription Specialists. Their website is qtskc.com. For pre-recorded or pre-produced captions and transcripts, if you're going to use YouTube auto captions, it's important to review them and make manual corrections. My experience is that if a video is longer than 5 or maybe 10 minutes, it's usually more cost effective just to hire someone to produce the captions for you. Rev.com is the vendor we use at DMH. For both transcripts and closed captions, they charge $1.50 per minute of content, so that's very cost effective. And their website is rev.com, rev.com. If you're having a live transcription or real-time captioning done by one of these providers, usually if you request a transcript in advance, they can provide that. But keep in mind, just like with YouTube auto captions, you may need to make manual corrections before you get your final product. You can also upload, if you have an accurate transcript or a script that you use to produce a video, you can take that and upload it to YouTube, and YouTube can auto synchronize it, which is usually pretty accurate, but you still want to double check that, and you can adjust that in post-production if you need to. For ASL interpreting and translation services, there's a list of vendors on the Missouri statewide contract that you can access at archive.oa.mo.gov/PURCH/contracts. And then under the search for keyword field, use the word interpret. If you use interpreter or interpreting, you're not going to get all of the options. So make sure you use the keyword interpret. And it's 3 o'clock. So thank you for your attention today. And my contact is on the screen. If you want to contact me afterward with any questions, or if you want to stay on the webinar for a few minutes, I am happy to take questions here as well. Thank you very much.
Thank you, David. And we do have a message in the chat from our captioner, and she's sharing that for ASL Interpreting and Translation Services, there is a list of vendors on the Missouri statewide contract.
Eileen, this is the captioner. That was supposed to be in the caption pod and it accidentally went to the chat. Sorry about that.
Oh, thank you. Okay.
Yes.
All right. And that's the only thing I see in the chat. You are welcome to open your mics and ask any questions you might have, or feel free to put something in the chat. Well, Scout Mary says, thanks, David. And I would double that. We appreciate your time. I'm not seeing any more questions or anything. Your session was jam full of information, which is so valuable. So thank you for your time. Thank you. Amy Nicholas says, thank you. And with that, I'm going to close the recording.